In the matter of Debra Dugan versus TGI Fridays, Inc., may we please have appearances?
My name's David Kott. I'm the attorney for the New Jersey Business and Industry Association, which has over 19,000 members, ranging from the largest companies in the state to the smallest companies. And I want to talk about one of our small members. It's a diner. Could be on Route 3 in Passaic County. It could be on Route 70 in Camden County. It's owned by an immigrant to this country. And he's a very good corporate citizen. He, in fact, reports all of his income. He follows the immigration laws. And he runs a good and clean business. But quite innocently, without any malicious intent, he violates a clearly established right of a consumer in some obscure state or federal statute or regulation. And he gets sued in a TICNOA class action. And the plaintiff says this class has no damages. Nobody in the class sustained any damages. The only relief that is sought is a $100 statutory penalty under TICNOA. Under Rule 4:32, a class action can only be certified when the court finds, quote, that a class action is a superior method to the fair and efficient adjudication of the controversy. So the standards are fair and efficient. And I would submit to you that in the example I gave, there is nothing fair about the certification of a class. After all, TICNOA is probably the broadest consumer protection statute in the country, has virtually no elements. Plaintiff does not have to sustain any damages to seek the $100 penalty. Plaintiff does not have to show reliance. Plaintiff does not have to show that the business intended to violate the statute. And on top of that, the potential damages of a class action judgment are extremely large because we have a $100 statutory penalty. You know, you think about a diner, open 24 hours, loads of customers coming day and night. It is a quintessential high volume business. And therefore the class is going to be large. And the damage award is completely disproportionate to two things. It's disproportionate to the actual damages the members of the class had, because the members of the class have no actual damages. They're only suing for the statutory $100 penalty. It is wholly disproportionate to the fault of the defendant, because in this example, the defendant's a good businessman who inadvertently violates TICNOA. So, we don't believe that class action in that context is fair, nor is it efficient. In 2011, the Appellate Division decided the local baking case, and they held that in TCPA cases involving only the statutory penalty, there would not be a class action allowed. And their reasoning was that a more efficient way to adjudicate that controversy was that instead of a class action, we would allow the plaintiff to file an individual action. And one thing we need to keep in mind is that under TICNOA, there's fee shifting. So that plaintiff who has that $100 violation will have no problem, if she has a valid claim, no problem finding a lawyer to prosecute the claim. Alternatively, as noted in local baking, if she wants to, she can file a pro se complaint in our special civil part. Every week, lots of cases are tried in our special civil part by pro se litigants. And in the TICNOA context, that trial for the TICNOA plaintiff is a very easy trial. She simply gets on the stand and says she was presented with the offending contract or the offending document, and that she read it. And she's made out her TICNWA case. She doesn't need any discovery from the defendant. She doesn't need an expert. She doesn't have to call any other witnesses. And she's going to get to verdict in about 4 to 6 weeks, because that's the typical time to verdict in a $100 case in the special civil part. So we would suggest that in the case of a TICNWA claim for the statutory penalty, $100, that it is not fair or efficient to certify it as a class action. And for that reason, we ask that this court hold, as did the Appellate Division in local baking, that in TICNWA cases seeking solely the statutory penalty of $100, that they not be certified.
When TICNWA was debated years ago, was there any discussion about the very issues that you just suggested and whether class actions would be the impact of a class action or potential limitations on it?
Not that I can find in the statute. You can read some of the words actually in TICNWA, and it's in one of the other amicus briefs. Some of the words can be read as contemplating an individual action, but I'm not sure everybody would read them that way. The other thing, and we referred to this in the Plain Language Act, and it's not completely responsive to Your Honor's question, but the Plain Language Act, which is in the same section as TICNWA, limits damages to $10,000. Now, we're not arguing for a limitation, but what the legislature was concerned on the Plain Language Act was just what I was referring to, and that is the impact on a business who innocently violates a Consumer Protection Act, in that case the Plain Language Act.
So how would a person who had patronized Fridays go to a small claims office, a small claims court, and prove that he or she was aggrieved? How would that person do it?
She would get on the stand and she would say, I went to Fridays on Thursday night. They presented to me a menu. I looked at the menu. I saw that they had Diet Coke. There was no price on the Diet Coke, and I purchased it. And she's made out her prima facie TICNWA case.
But okay, so how is that person going to prove damages? It seems to me from listening to Mr. Jacobson, and he's nodding, to prove aggrieved, you're going to have to show that the person would have paid less.
Well,
Oh, no, or more? No? Okay.
and-
Trying to get my instructions from Mr. Jacobson.
as I've said publicly, and I've submitted a lot of amicus briefs
Go ahead.
to this court, I'm here. as a-
I'm trying to.
But let me
ahead.
try to help the court.
Go ahead.
On this one, I want to try to help the
Good.
court. The aggrieved issue is an issue that is all over the place, both in the federal court and the lower courts. Third Circuit has asked this court to accept certification in Spade and Wegner, and as of yesterday, my law librarian says that the court has not yet ruled on the certification. But there's a real dispute between the plaintiff's bar and the defense bar as to what exactly aggrieved means. And I'll give you in the record in this case, if you go back in the record in this case, or in Bozzi it might be, but one of the plaintiff's lawyers would say anybody who received a menu was aggrieved, whether or not they read the drink section or whether or not they purchased a drink. Not surprisingly, the defendants have a different view of aggrieved. So the aggrieved issue is a complex issue substantively, but what's not complex in this case is that presentment, everybody agrees, is required. And as soon as you require presentment, you have, on the TICNWA class action, you have highly individualized issues.
The reason why I raise it, and it doesn't have to be in the TICNWA context, it could be in the consumer fraud context. A single person going into small claims cannot do what plaintiff's counsel representing a class has done, and that is engage in discovery and get the documents of the survey to show that, as they're alleging, at least for purposes of the hearing now, that Fridays decided that if they posted the drinks, they'd have to charge less, but if they didn't have to post them, they could charge more. Like, how would an individual, okay, representing himself or herself, be able to pursue a claim and get damages in small claims court?
I would suggest to Your Honor that you're conflating the Consumer Fraud Act claim and everything.
No,
you just
no,
asked
I
me
am,
about.
I am.
Okay.
I am.
And
yeah.
I'm not here arguing on the Consumer Fraud Act. And in fact, I've been fairly careful, as of the other amici. On the TICNA, we're not arguing no class action when a plaintiff actually has damages. We're just talking about no class action under TICNA when the claim is, I have no damages, but I want the $100 statutory penalty. So in your situation, if I were saying no class action in consumer fraud, then I think Your Honor's question would make sense. But for TICNA, and I come back to what I said before, the elements are presentment, and then an aggrieved consumer, and at some point I assume we're going to learn exactly where on the spectrum aggrieved consumer is.
I take it you're not arguing that there could not be circumstances where TICNA could be the underlying basis for a class action?
Oh, no, I'm not, yes,
Okay.
I'm not arguing that at all. If the consumer has damages, and we have TICNA cases where the consumers can point to damages, I'm not here, and I don't think any of the amici on our side are here saying there should be no class action. What we're talking about is this $100 statutory penalty classed up for a diner or classed up for a small business.
Thank you.
Thank you, Your Honor.